Hello, this is Kip from Malik. Today I'm going to be just going over the basics of intentional torts in relation to workers' comp claims. And kind of the reason why I'm going over this is because a common thing for injured workers to do is to say, hey, I want to sue my employer. And then the common answer, or the answer that I always have to give them is, in workers' comp, you can't sue your employer. You file a workers' comp claim, that's a remedy. There is a very limited basis to sue your employer, and it would be an intentional tort. And it's very, very, very rare to have an intentional tort. And what I'll do after this video, in the future videos, I'll go over cases that have dealt with intentional tort. So fundamentally, you have to go to the Ohio Constitution. We go to Section 3, Article 2 of the Ohio Constitution, and this states the Workers' Compensation Act provides that a participating employer shall not be liable to respond in damages at common law or by statute for death, injuries, or occupational diseases of its employees. So again, that's the Ohio Constitution. That's the law that gives rise to workers' comp, etc. And again, clearly states you can't sue in common law. And what that basically means is you can't sue you can't file like a personal injury case. So that's the basics of where we're coming from, and then that's the basic rule. So let's see if you have an intentional tort. And the reason why it's really hard to have one of these is the following. To establish an intentional tort, the employee must prove by clear and convincing evidence. So that's a fairly high burden of proof. So if you have just a base level workers' comp case, like you're going to court, you have to prove by a preponderance of the evidence. That's the standard if you have just the basic 512 appeal, i.e. you're trying to go to court and get the right to participate for the initial allowance or an additional condition in your workers' comp case. And that would be preponderance of the evidence, and that's more likely than not, so that'd be 51% if you want to put a percentage to it. So what this is saying is to prove the intentional tort, you have to prove the elements of the case by clear and convincing evidence, and that's pretty high. So what's clear and convincing? Clear and convincing is evidence is highly and substantially more likely to be true than untrue. And if you want to put a percentage of that, you might think maybe 75%, which is, that's fairly high. Now, if we had a criminal case, which this is not, that's the highest burden of proof, and that's beyond a reasonable doubt. So that, if you want to put a number to that, that'd be maybe 90% or higher. So again, for a 512 case, it's more likely than not, preponderance of the evidence standard. So it's 51% or higher. If you prove the elements of your case, then you win. For intentional tort, we're looking at clear and convincing evidence. So you have to prove your case by 75% or more. And then if it's a criminal case, it's beyond a reasonable doubt. Okay, so that's the standard of proof. And so what an intentional tort is to establish that, again, you have to prove by clear and convincing evidence that the employer deliberately committed all the elements of an employment intentional tort pursuant to a revised code 2745.01b. Okay? And the Ohio Supreme Court has established the following three elements are necessary to prove an intentional tort. So number one, and this is important, you have to have all three. If you have 1 and 2 but not 3, or if you just have 1, then you don't have an intentional tort. You might have a horrible injury, you might have grievous injuries, you still will not have an intentional tort. So number one, knowledge by the employer of the existence of a dangerous process, procedure, instrumentality, or condition within its business operation. So they have to have knowledge of something dangerous, in the work environment. And then that's number one. You have to establish number one. Number two, knowledge by the employer that if the employee is subject by his employment to that dangerous process, procedure, instrumentality, or condition, its harm to the employee will be a substantial certainty. So number two is basically saying, hey, if the employer knows that if an employee is exposed to this dangerous thing, doing a job in a particular way or using a machine that's dangerous, and they know that harm is substantially certain to occur. So they know that if they subject their employee to that, whatever that thing is, that process, that machine, etc., then it's a substantial certainty that harm to that employee will occur. So they have knowledge of that will occur. So that's number one and number two. And then number three, that the employer, under such circumstances with such knowledge, did act to require the employee to continue to perform that dangerous task. So that's why these things are really hard to prove, because you might have like an instrumentality process, etc., that is dangerous. But if you can't prove that the employer had knowledge of that, then no intentional tort. So the knowledge that they have to have is substantial certainty. And I'm going to go over some, like I said, some intentional tort cases. They're kind of, eye-opening. And I'm just because I've read this case, there's a case that was kind of nuts. I had to research it because one of my clients was looking into that, interested in me looking into it. But if I could remember, it was like a truck driver or a box truck driver, and they were using a, they went out for work that day in the box truck, and then when they're turning around in a curve or something, the box truck's brakes went out, and then they end up going off the road and hitting a tree and getting really badly injured. And if you read that case, and I'll discuss it again in another video, but if you read that case, they talk about the employer knowing that the brakes in this truck were screwed up, and they were in bad shape, but that employee still was not able to prove an intentional tort because they didn't know the brakes were going to fail. They didn't have knowledge of substantial certainty that the brakes were going to fail and that the employee was going to run off the road into a tree. So that's how draconian and how intense these intentional tort cases can be. And that's why, again, you might have a horrible injury, just bad. It was super negligent for the employer to have you do what you were doing, but it still might not rise to the level of an intentional tort. And that's most of the time, I'd say 99% of the time, that's going to be the case. It's just a very high burden that Ohio has placed on employees to prove intentional torts. Now, if you don't have an intentional tort, you may have a VSSR. Okay, so we've talked about VSSRs. They kind of sometimes they go hand in hand, but that might be some way that you could get a remedy if you've been injured in a horrible way, and it just seems like you got injured in doing whatever this process is, and it was just really unsafe. So that's intentional torts. Again, as I always recommend, or I always advise you folks, always get an attorney involved with your workers' comp claim. Ask your friends, families, neighbors, coworkers who they use to rep them, and go with that person, because this workers' comp stuff is unnecessarily complicated. It's just going to pay you dividends to get somebody involved. So anyways, that is the basics of intentional tort. Stay safe, and I'll see you in the next video.